My parents reported my car stolen. After I refused to give my sister $15,000, Ms. Okafor didn't wait for permission. Your parents' home was sold 4 months ago, she said, sliding a recorded deed across the table, to a private lending firm called Silverleaf Capital Partners, following a default on a bridge loan taken out against the property. The sale was structured as a deed in lieu of foreclosure, meaning your parents avoided a public foreclosure notice by voluntarily signing the house over. They've been living there since as tenants, paying Silverleaf rent, under a lease neither of them mentioned to you. I stared at the recorded deed, the county stamp in the corner, a signature date that landed exactly 2 weeks after Lauren's 30th birthday party, the one where my mother had cried happy tears over a rented photo booth. They don't own their house, I said slowly, and they asked me for $15,000 anyway. The $15,000 was the current month's rent and a penalty fee, Ms. Okafor said. Silverleaf's servicing notice went out 9 days before your family dinner. I want you to sit with that detail the way I had to sit with it, because it's the piece that changed how I understood every single thing that came before it. My parents hadn't been trying to help Lauren with some vague family emergency. They'd been trying to make their July rent payment on a house they no longer owned, using money extracted from a daughter they'd already stolen $300,000 from without her knowledge. There's one more thing, Ms. Okafor said, and her voice dropped into the particular register people use right before they hand you something they know will hurt. Silverleaf's loan file lists a personal guarantor on the original bridge loan, someone whose credit and assets back the debt if your parents ever stop paying. She turned the folder around. My name, my forged signature, the same crooked, unconvincing scrawl from the power of attorney, notarized on a personal guarantee agreement 18 months earlier. If Silverleaf's loan servicing team ever audits that file and finds a payment default, Ms. Okafor said, they have the contractual right to pursue the guarantor directly. That would be you. My hands went cold before my brain caught up to why. I wasn't just the victim of a family betrayal anymore. I was, on paper, financially responsible for a debt on a house I'd never lived in as an adult, a debt my own father was 3 months late on, according to Silverleaf's own servicing notice sitting in that folder. I need to back up here, because there's a version of my childhood I believed for 29 years, and it matters that you understand it before I tell you how completely it came apart. I grew up the responsible one. That was my role in the family long before I had the vocabulary to recognize it as a role instead of a personality. Lauren got the piano lessons and the study abroad semester and the car with heated seats for her 16th birthday. I got a scholarship, a work-study job at the campus library, and my father's genuine, if backhanded, praise. Emma doesn't need help. Emma figures things out. I used to think that was a compliment. I understand now it was a job description. I was the daughter who didn't need managing, which made me eventually the daughter whose name was quietly useful to manage everything else. Caleb had met my parents exactly 4 times before that dinner. Always polite, always a little watchful, in the way cops learn to be watchful even off duty. He told me once, early in our relationship, that my father reminded him of men he'd arrested for check fraud, not because he'd done anything specific, but because of the particular way he made eye contact a half-second too long when he was asking for something. I'd laughed it off at the time. I stopped laughing about it somewhere around the 4th folder Ms. Okafor slid across that table. There's a memory I keep circling back to from when I was maybe 11. My father had lost his job that year, quietly, the way he lost most things. And one night, I found him at the kitchen table with a stack of unopened envelopes, the kind with red print on the outside. He saw me looking and folded his hands over them like a man covering cards at a poker table. This is grown-up business, he said. You don't need to worry about it. 2 weeks later, he asked me, an 11-year-old, to sign a birthday card to my grandmother, extra neat, because his hand was cramped from writing checks all day. I didn't think anything of it at the time. Children rarely do. It's only now, sitting across from a bank investigator with a magnifying glass and a forged power of attorney, that I understand I'd been practicing my signature for his purposes, since before I understood what a signature was for. Detective Marcus Reyes joined us 20 minutes later. 13 years with the department's financial crimes unit, the kind of tired, patient energy that comes from having heard every excuse a person can invent for stealing from their own family. I want to be straightforward with you, Emma, he said, once Ms. Okafor had walked him through the deed and the guarantee. Forgery and identity theft cases involving family members are some of the hardest we prosecute, not because the evidence is weak, but because victims change their minds. They get scared of what happens to their parents. They start minimizing. I need to know now whether you're going to be that kind of witness. I watched armed officers surround my car 3 nights ago because my father told them I was dangerous, I said. I'm not confused about what he's capable of. Detective Reyes nodded slowly, the first genuine approval I'd seen from him. Then let's talk about the timeline. because it's worse than the room you're sitting in right now. He laid out what his preliminary financial subpoenas had already uncovered, working backward from the Silverleaf guarantee: 6 years of escalating debt, 3 refinanced mortgages, 2 personal loans taken against my father's now-defunct consulting business, and, buried in year 4, a forged co-signature on an auto loan for Lauren's car, the heated seat one from her 16th birthday, except the loan itself hadn't been taken out until she was 24, refinancing a car that should have been long paid off. There's a pattern in the timing, Reyes added, sliding a printed spreadsheet across the table, dates in one column, dollar amounts in another. Every major refinance lines up within a few weeks of some family milestone. Lauren's birthday, your college graduation, your engagement announcement. It's like he used the good moments as cover, banking on everyone being too distracted celebrating to look closely at the paperwork moving underneath it. I thought about my own engagement dinner, 6 months earlier, my father raising a toast with tears actually visible in his eyes, and I wondered, sitting in that small room with Reyes's spreadsheet in front of me, what had been signed that same week while we were all busy believing him. Your sister's name is on some of this too, Reyes said. Whether she knows that is a separate question. That question sat in my chest like a stone for the rest of that day. Reyes came back to my apartment 2 evenings later with a banker's box of subpoenaed records, and Caleb and I spread them across our kitchen table like we were assembling a jigsaw puzzle nobody wanted to finish. Utility bills in my name for an address I'd never lived at, a homeowner's insurance policy listing me as a co-insured on my parents' house, a house Reyes now confirmed had been quietly refinanced twice under that same policy to justify larger and larger loan amounts, a gym membership opened in my name the same month I'd been living 4 states away for a summer internship, its address matched to my parents' house, its monthly statements mailed there and never once forwarded to me. It's not just the big numbers, Reyes said, tapping the gym membership statement. It's every small one too. Somebody built an entire second version of you on paper that never left your parents' zip code. That takes years of deliberate paperwork. That's not one bad decision. That's a system. Caleb didn't say much while Reyes talked, but I felt his hand find mine under the table, and I understood, without either of us saying it, that we were both doing the same math. How many small stolen fragments of a person does it take before you can no longer call the theft an accident? My father's attorney called me the following afternoon, not to apologize, to warn me. Ms. Voss, I'm calling as a courtesy, said a man who introduced himself as Todd Bregman, retained, he said, to manage the family's exposure. Your father is prepared to characterize any further cooperation with law enforcement as retaliation stemming from a personal financial dispute over wedding expenses. I'd encourage you to consider how that narrative plays out publicly before you continue escalating this. You're threatening to tell people I did this over wedding money. I'm advising you that families who air these disputes publicly rarely come out looking sympathetic, regardless of the underlying facts, Bregman said, in the smooth, practiced tone of a man paid specifically to make threats sound like courtesy. There may still be a private resolution available here, a repayment plan, a quiet correction to the guarantee paperwork. No need for anyone's name to appear anywhere permanent. I understood, listening to him, that this was the same offer my father had been making our entire family for years, just repackaged in a lawyer's vocabulary. Stay quiet, absorb the cost, let the appearance of a functioning family matter more than the truth of one. I'd absorbed that offer at 18 when my name went on the car loan I didn't know existed yet. I'd absorbed it at 22 when I found out secondhand that my gift toward Lauren's study abroad program had actually been a loan drawn against my own newly opened credit file. I wasn't going to absorb it again at 29, 3 days after 2 patrol cars had pointed spotlights through my windshield. Your father wanted me to mention, Bregman added, when I didn't answer right away, that he still considers you his daughter, and that none of this needs to end the relationship, provided cooler heads prevail. Cooler heads, I repeated. Is that what you call it when a man sends armed police after his own daughter over a rent payment on a house he doesn't own? There was a pause on the line, the kind lawyers use when a client has said more than they should have, and they're deciding how much damage control is possible. I wasn't aware the house was characterized that way in any filing, Bregman said carefully. It will be, I said. Soon. Tell my father, I said, that my only conversation about this happens through Detective Reyes from now on. I hung up before Bregman could answer, and my hands were shaking again, but it was a different shake than the one on the highway. That one had been fear. This one was something closer to resolve finding its footing. The failed attempt that still makes my stomach turn happened 2 days later, when my mother showed up at my apartment unannounced, alone, no makeup, looking smaller than I'd ever seen her. The failed attempt that still makes my stomach turn happened 2 days later, when my mother showed up at my apartment unannounced, alone, no makeup, looking smaller than I'd ever seen her. You have to stop this, she said, standing in my doorway, refusing to come inside. He's going to lose everything. We already lost the house, Emma. Do you understand what's left for him to lose? I understand exactly what's left, I said. My credit, my name, possibly my own house someday, if Silverleaf ever comes looking for their guarantor. He never would have actually let it get that far. He already let it get that far, Mom, I have the paperwork. He's 3 months behind on rent for a house he doesn't own, using my forged signature as collateral for a debt I never agreed to. Her face did something complicated, guilt and defensiveness fighting for the same real estate. I didn't forge anything. No, I said quietly. You just sat at that dinner table and told me family came before my wedding, knowing exactly where that $15,000 was actually going. She didn't deny it. That was the part that finally, completely closed a door in me that had been propped open my whole life, waiting for her to walk through it and explain herself into forgiveness. You were always the strong one, she said, softer now, like she thought a gentler tone might work where the guilt hadn't. You never needed things the way Lauren did. I thought that meant you could handle this too. I could handle a lot of things, Mom. I could handle a lot of things because nobody ever gave me a choice about whether I wanted to. That's not the same as it being fine. She flinched at that, the smallest movement, like the words had actually landed somewhere. For a second, I thought she might finally say something true. Instead, she asked, so what happens now? Are you really going to let them arrest him? I'm not letting anything happen to him, Mom. He did this. I'm just done pretending I didn't notice. She just stood there, and after a long moment, she turned and walked back to her car, and I watched her go without calling after her, which felt like its own kind of grief, separate from anger, quieter and more permanent. I called Lauren that night because Detective Reyes's sentence about the auto loan hadn't left my head. She answered on the second ring, already crying before I said more than her name. I know about the car, she said. The detective called me yesterday. Emma, I swear to God I didn't know. I thought Dad paid that off years ago. I've been driving around for 5 years in a car with my name on a loan I never signed for, at an interest rate I didn't even know existed. I believed her, mostly because of how genuinely confused she sounded doing the math out loud. The specific bewilderment of someone realizing the floor of their adult life had never actually been solid. He told me you needed the $15,000. I said. For what, Lauren? What did he actually tell you? He said it was for my wedding deposit next year, she said, and I heard something break a little further in her voice. There's no wedding deposit, Emma. I'm not even engaged yet. I don't know what he needed that money for. I don't think I ever really knew what any of the money was for. We didn't fix anything on that call. We didn't need to. It was the first honest conversation we'd had in years. Both of us finally comparing notes on a father who had apparently been running 2 separate versions of the same con on each of us the entire time. She asked to meet in person a week later, at a coffee shop halfway between our 2 apartments, neutral ground neither of us had any history with. She brought a folder of her own, printouts of the auto loan statements she'd pulled that morning, highlighted in 3 different colors like she'd been up half the night trying to make sense of them. I called the lender myself, she said, sliding the folder across the table, an unconscious echo of Ms. Okafor that neither of us mentioned out loud. They said the loan was refinanced under my name with an updated income verification. I've never submitted an income verification to anyone in my life. I don't even have the kind of job that generates one. Someone submitted it for you. Someone submitted a lot of things for both of us, apparently. She turned her coffee cup slowly on the table, not drinking it. Emma, I need to ask you something, and I need you to actually answer honestly. Did you know this whole time that I don't know, a symptom of something instead of just his favorite? The question surprised me enough that I laughed. Not because it was funny, but because it was the first time in 29 years either of us had said out loud what we'd both clearly suspected. I thought you were the one who got everything, I said. It never occurred to me that getting everything could also be a trap. Turns out it's a really specific kind of trap, she said. And for the first time since the dinner that started all of this, we weren't performing anything for anyone. We were just 2 sisters, comparing the shape of the same cage from 2 different corners of it. The crisis peak arrived 9 days after the bank meeting, in the form of a certified letter from Silverleaf Capital Partners Collections Division, forwarded to me by Ms. Okafor the moment it hit my parents' address. Since her office had flagged the account for monitoring, notice of payment default, guarantor liability activation, Silverleaf's servicing team had finally run the routine 90-day delinquency audit on my father's account, and my name, sitting quietly on that forged guarantee for 18 months, had surfaced exactly the way Ms. Okafor warned it eventually would. I had, according to the letter, 14 days to cure the default or dispute the guarantee in writing before Silverleaf initiated collection proceedings directly against me, including a lien filing against any real property in my name and a formal request for wage garnishment through my employer. 14 days. I sat at my kitchen table at 11 p.m., reading that letter for the 4th time, Caleb across from me, both of us doing math on a legal process neither of us fully understood yet. If I dispute it, I said, I need to prove the signature is forged, formally, in a way Silverleaf's legal team can't just wave away as a family disagreement. Then we need someone whose entire job is proving exactly that, Caleb said. That's how I ended up 3 days later, in a small, cluttered office with Walter Kim, a forensic document examiner certified by the American Board of Forensic Document Examiners with 18 years in the field, comparing my actual signature against the guarantee agreement under a lighted magnifier while he narrated his findings into a recorder for the file. Your genuine signature shows consistent pen pressure and a distinctive backward loop on the capital E, Kim said, tracing it with a gloved finger. The guarantee signature shows hesitation marks. here and here, consistent with someone tracing rather than signing naturally. And the ink dating is inconsistent with the document's stated execution date. This wasn't just forged. It was forged carelessly by someone who assumed no one would ever look closely enough to notice. Will that hold up against Silverleaf's attorneys? It held up in front of federal juries for 18 years. Kim said. I imagine it'll survive a collections attorney. He walked me through the rest of it methodically, the way I imagine a surgeon narrates an operation to a nervous patient, less for the record than to give the frightened person in the room something to hold on to besides fear. Forgers usually fail in one of two ways, he said. Either they trace too carefully and the line quality looks dead, no natural variation in speed or pressure, or they don't trace at all and rely on muscle memory from watching the real signature, which produces something close but subtly wrong in the letter proportions. Yours is the first kind. Whoever did this had access to an actual sample of your signature and traced it directly, which tells me it wasn't a stranger. It was someone with time alone with your handwriting and no fear of getting caught looking. I thought of the birthday card. Extra neat, my father had said. I didn't tell Kim that detail. Some things you keep for the version of the story you tell yourself at night, not the one you give to a man wearing a jeweler's loop. Attorney Priya Nandan, who Ms. Okafor had recommended, specializing in consumer fraud and identity theft litigation for 9 years, filed the formal dispute on my behalf within the 14-day window, attaching Kim's forensic report, Detective Reyes's active criminal referral, and a sworn affidavit from me establishing that I had never executed, witnessed, or consented to the guarantee agreement in question. Silverleaf doesn't actually want a forgery fight, Priya told me over the phone the day she filed. Litigating a contested guarantee against forensic evidence this clean is expensive and embarrassing for a lender who's supposed to verify signatures before extending credit. My guess is they quietly release you from the guarantee within 30 days and go pursue your father directly for the remaining deficiency. She was right, though it took closer to 41 days and an unpleasant round of calls from a Silverleaf in-house collections attorney named Grant Holloway, who tried twice to suggest that my family relationship made me a more efficient collection target than pursuing a defaulted borrower with no remaining assets. On the second call, Priya put him on speaker so I could hear it directly. We're simply exploring the most efficient path to recovery for our client, Holloway said, his tone the particular flavor of polite that people use right before they say something indefensible. Given the family dynamics involved, a private arrangement between Ms. Voss and her father might resolve this more quickly than protracted forensic litigation. My client isn't a collection strategy, Priya said. She's a forgery victim with a certified forensic report and an active criminal referral. If Silverleaf wants to keep floating theories about family dynamics, I'll be happy to attach this call transcript as an exhibit the next time we're in front of a judge. Holloway didn't call again after that. Priya told me afterward, with the flat satisfaction of someone who'd had this exact conversation more times than she could count, that most collections attorneys fold the moment they realize the person on the other end has already lawyered up with someone who knows exactly which threats are bluffs. Both times, the tenor of Silverleaf's correspondence changed noticeably afterward, the particular shift you learn to recognize once you've watched enough institutions realize they picked the wrong target. Assistant District Attorney Grace Liu picked up the criminal case from Detective Reyes's referral 6 weeks after the bank meeting, and she called me personally before the grand jury convened, which she told me she didn't always do, but wanted to, given how directly I'd been targeted by the same scheme I was being asked to testify about. I want to walk you through what a jury is going to hear, she said, because I don't want anything in that room to surprise you the way your family has clearly been surprising you for months. We're charging your father with forgery, identity theft, and bank fraud, tied specifically to the guarantee agreement and the false police report. Your mother is not being charged criminally at this time. Knowledge after the fact isn't the same as participation, legally. Even though I understand that distinction probably doesn't feel like much comfort, it didn't. But it was, at least, the truth stated plainly, which had become a rare enough commodity in my family that I'd started keeping a mental inventory of every person who offered it to me without flinching. You'll be asked to testify, Liu said. I won't pretend that's going to be easy. His attorney is going to try to make this look like a family dispute that got out of hand, because that's the only defense that has any chance of working with a jury. Your job isn't to be angry on the stand. It's to be exact. Dates, documents, what you knew and when you knew it. Let Kim's report and Reyes's timeline carry the emotional weight. You just carry the facts. I can do exact, I said. I've had a lot of practice being exact. It's mostly what he trained me for, just never for this. Liu didn't laugh, but something in her expression shifted. The particular recognition of someone who'd prosecuted enough family fraud cases to know exactly what I meant without needing it explained further. The grand jury heard everything over 2 days. Kim's forensic analysis, Reyes's financial timeline stretching back 6 years, the recorded phone call where my father demanded $15,000 and then went silent for 3 full seconds when asked about loans he claimed not to understand, and the body camera footage from that highway, my hands shaking on the wheel, Caleb's voice cutting through the chaos. She's my fiancé. My father was indicted on 11 counts. He hired a new attorney once Todd Bregman quietly withdrew from the case, citing, according to the withdrawal filing, irreconcilable differences regarding case strategy, which I understood to mean he'd finally read the forensic report himself. He took a plea deal 4 months later rather than let a jury hear Walter Kim testify about hesitation marks and traced signatures in open court. 6 years, with restitution ordered to me and to the auto lender on Lauren's car, an amount the judge at sentencing called a fraction of what this defendant actually cost the people who trusted him most, precisely because trust is not something a court can restore by ordering a check. I didn't go to the sentencing. Lauren did. She told me afterward that our father looked directly at her, not at me, when the judge read the restitution order, like some part of him still believed she was the daughter he needed to manage, and I was simply the daughter who'd stopped being manageable. My mother filed for divorce 8 weeks after the plea deal. I don't know everything that happened in their marriage behind closed doors, and at this point, I've stopped trying to reconstruct a version of it that makes sense to me. I know she called me once, 3 months after the sentencing, and told me she was sorry, and I told her I believed she meant it, and that meaning it, and earning back what she'd spent 29 years teaching me not to expect from her, were 2 very different projects, and I wasn't sure yet which one, if either, we were actually starting. She asked, near the end of that call, if I could ever imagine trusting her again with something small, a birthday, a holiday, the ordinary texture of a family that wasn't built entirely on management and money. I told her I didn't know yet, and that I thought the honest answer mattered more to both of us than a comforting one. She said she understood. I believed that too, mostly the way you believe a person is finally telling you the truth once they've run out of easier options. Detective Reyes called a final time the week before the wedding, not about the case, just to let me know he'd closed his file. Most of these end with the victim more exhausted than relieved, he said. You built something out of it instead. That's rarer than you'd think. Caleb and I got married that spring, in a small ceremony we paid for with the exact $15,000 my father had once demanded I hand over, still sitting untouched in the account where we'd left it the whole time. There was a moment, standing at the front of that small room, where I caught myself doing the math on who wasn't there, an old reflex I'm still unlearning, before I made myself just look at Caleb instead and let that be enough. Lauren came. She cried through the vows, the real kind this time, not the rehearsed kind from that dinner table, and afterward she told me she'd started seeing a financial counselor to untangle exactly what was actually hers and what had quietly never been. She'd also, she told me over cake, started keeping copies of every document with her own name on it in a safe deposit box under her own key, something neither of us had thought to do until we'd learned the hard way what happens to a family's paperwork when only one person controls where it lives. I used to think you got the easy version of this family, I told her, because you never had to be the responsible one. I used to think you got the easy version, she said, because nobody ever tried to disappear you into a spreadsheet. Neither of us laughed exactly, but something lighter passed between us anyway. The particular relief of 2 people finally agreeing on which parts of the story had actually happened. I think about Ms. Okafor's sentence sometimes, the one she said right before my father's face lost its color. Emma needs to understand who actually owns your house. It wasn't just about a deed or a servicing notice. It was the first true sentence anyone in my family had said to me in years, and it turned out to be the thread that unraveled all the rest of them. I've since learned that most families like mine don't unravel from one dramatic betrayal. They unravel one quiet, overlooked signature at a time, and somebody eventually has to be the one willing to look closely enough to notice. They spent 29 years telling me I was the responsible one, the one who didn't need help, the one who figured things out. They just never expected me to figure out exactly what that had always meant.